we're ready to proceed until such time as the state seeks to offer that type of evidence.
You rather do it right now? I mean, you intend on going in, I'm sure.
Your Honor, I think that the first question on the Castor issue is, and the Garrity issue, is whether the walkthrough was a Garrity statement. So the state's intention, based on the motion that was filed yesterday, is to start with that factual issue and call 3 witnesses related to whether the walkthrough was a Garrity statement.
Good morning, Judge.
Hi.
How are you?
Welcome. Mr. Vanderslice told you that you were coming. So you're asking me to do this before opening statement. You don't want me to do it before opening statement?
Before the state offers any evidence.
Do you intend on making reference to anything that you're seeking to get into during opening statement?
Yes, Judge. The state's impression, based on other filings by
Judge,
the
is this
defense.
discussion on the record?
No. I'm just trying to get my bearings straight.
Judge, based on the
Give me a
other
preview.
filings that the defense has made, including the application for writ habeas corpus, the motion to accuse, the defense is of the theory that the walkthrough that the defendant did with the Dallas County Sheriff's Office was a Garrity statement.
No, I know. I get that.
I'm sure Mr. Snipes wants to talk about that during opening statements. The motion in limine, if it is to limine out any evidence that was affected by the walkthrough, would limine out the entire prosecution, which is absurd.
No,
So we need to
okay.
we need to address whether the walkthrough was a Garrity statement, probably pre-trial.
Okay, I'm going to do that. Let's go on the record. This is cause number F1718595, F1700576, and F1700579. The record should reflect that Mr. Oliver is present in court today with Mr. Lane, Mr. Gill, Mr. Brissett, and their team. The state is represented this morning by Mr. Snipes. I believe Mr. Gladden will be handling an initial hearing. Mr. Higginbotham is here, and the prosecution's team is here. The reason why we're here is because the defense filed yesterday or last night, I'm not sure which, but yesterday, a motion in limine regarding certain evidence under Garrity that they are seeking to prevent the introduction of. The state has responded that they wish to put evidence on this morning. Do you wish to do this by witness or by offer of proof?
Just, we can do an initial offer of proof, but I think witnesses are going to be necessary.
It seems to me that, well, I'll trust your judgment on that. Do you have a preference either way?
Judge, our motion
8:50
was before any evidence or testimony is presented.
I understand.
Judge, if I may.
Go ahead.
Under Garrity and Cascagar, the defense has an initial burden of showing that there was a Garrity statement to begin with, where the state has the burden of showing whether it affected any evidence or testimony. So what the state would ask at this point is for the defense to specify specifically what Garrity statement they are alleging has influenced this case, so that we know what evidence we have to put out at a pretrial hearing.
What's your response to that, Mr. Gill?
My response is that it sounds like the state wants to have the court grant our writ of habeas corpus and hear this issue pre-trial.
I don't know that I heard that. I'm going to just take this by offer of proof. I don't think that any of these facts are in dispute. Whether or not it's a Garrity claim is valid or not seems to me to be a legal question. So why don't you make the offer of proof and I'll go forward from there.
Judge, can I clarify?
Sure.
As an offer of proof, do you want me to just make factual assertions to the court?
Right.
Okay. Judge, have you received the copy of our response?
Yes, I did.
Okay, I wasn't sure if I was in here when you received that.
I did receive it.
There are at least,
And Judge, for the record, we received it about 10 minutes ago.
That's about when I received it.
that's about when we filed the judge. I think there are some factual disputes, Judge. I will make an offer, and then the court can decide. There seems to be an allegation from the defense of two potential Garrity statements. And this is to be gleaned from the defense's other filings in this case. One, the defense says that the walkthrough conducted with the Dallas County Sheriff's Office on April 30th, 2017 was pursuant to and following a Garrity warning administered by Lieutenant Merritt of the Balch Springs Police Department. And the second statement alleged in the defense's filings is that the defendant gave a written statement pursuant to and subsequent to and following another Garrity warning on May 2nd, 2017 to Lieutenant Merritt, and that was a written statement. The state believes that those are not entirely accurate representations to the court. The state would show this court that on April 30th, 2017, the defendant was at the Balch Springs Police Department with his attorney to meet with Lieutenant Merritt. Before they could speak to Lieutenant Merritt, the defendant's attorney tried to provide Lieutenant Merritt with a written statement. Lieutenant Merritt asked the defendant's attorney to hold off on that until they could do a proper Garrity procedure for the internal affairs investigation. At that point, the state believes Lieutenant Merritt provided the defendant with an internal affairs packet. And this packet contained a complaint, an allegation, a written Garrity warning that Lieutenant Merritt administered to the defendant, and then a constitutional protection statement for the defendant to sign. That protection statement has been filed by the defense as an exhibit on their motion to recuse. And that is signed by the defendant at 3:20 a.m. on April 30th. The state believes that following that procedure where the defendant signed the constitutional protection statement, the defendant and his attorney reviewed body-worn camera footage and then submitted a written statement at that time on April 30th. That written statement is a Garrity statement because it was in response to these Garrity warnings, and it was part of the administrative internal affairs investigation conducted by the Balch Springs Police Department. The state then believes that 2 hours later, as part of an independent criminal investigation conducted by the Dallas County Sheriff's Office, the defendant was asked through his attorney, Cindy Stormer, to participate in a walkthrough of the shooting scene. So the defendant and his attorney went to the scene and met with Dallas County Sheriff's detectives. Lieutenant Merritt was present, but the state proffers that Lieutenant Merritt said nothing during this walkthrough and heard nothing during this walkthrough. The walkthrough was directed by the Dallas County Sheriff's Office and was independent of the Balch Springs internal investigation. So the state's proffer to this court is that the walkthrough was not a Garrity statement.
All right. What is it that you intend on offering that's a result of this walkthrough? Are these oral statements? Are they pictures? Are they videos? What are they?
Judge, the evidence that was influenced directly or indirectly by that walkthrough would include any evidence that was sought out by the Dallas County Sheriff's detectives after the walkthrough occurred. For example, the search warrant to do ballistics analysis from the scene that Detective Better prepared, certain facts in that search warrant came from the defendant's statements during the walkthrough. So that's an example of the evidence. Basically, I guess the state's point is that if the walkthrough were a Garrity statement, which it's not, most of the evidence in this case would be tainted by it.
Well, I think that's what Mr. Gill says.
Yeah, that's certainly what Mr. Gill says.
But listen, I guess this is what I'm asking. There's a motion in limine here. What evidence are you seeking to introduce specifically that I need to rule on whether or not there was a Garrity violation that would prevent its admission?
Judge, it would be the testimony of any detective who was present at the walkthrough, which would be Detective Carranza and Fetter. And then any...
What evidence is that? Are you talking about statements of Mr. Oliver? Are you talking about a video? Are we talking about pictures? What are we talking about? What's the evidence?
Judge, it would be at the start their testimony and no documentary or physical evidence offered through them.
These are observations that they're making as they're going through the crime scene?
Yes, Judge.
Is there anything that's going to be attributed to Mr. Oliver?
Judge, I don't know.
Well, somebody over there needs to know.
No, sir.
Okay. So we're not talking about any statements, we're talking about impressions, we're talking about things that these officers saw?
Yes, Judge.
Is that right?
The issue is that under Castigar, if the walkthrough was a Garrity statement, then the state has a heavy burden of showing that even those impressions were not influenced by the defendant's statement. That's the issue, is we're not talking about just direct evidence obtained, we're talking about direct or indirect use of an allegedly immune statement. And so the initial legal question is whether that statement is protected by use or derivative use immunity.
Okay. You talk about an independent criminal investigation versus this administrative proceeding or investigation that was done by Lieutenant Merritt. What separates the two?
Judge, the two are separated really by two facts. I would proffer to the court that the Balch Springs Police Department has written general orders specifying that in a serious allegation or a serious complaint, the investigation is in two separate tracks, an internal investigation and a criminal investigation. In this case, the criminal investigation was not even handled by the Balch Springs Police Department, but by the Dallas County Sheriff's Department. So in that sense, Mr. Oliver knew that there were two separate proceedings going on pursuant to the general orders of his employer, and that in this case, the proceedings conducted by Lieutenant Merritt were the investigative proceedings or the internal proceedings where he had Garrity rights, while the investigation by the Dallas County Sheriff's Department was a criminal investigation where he did not have Garrity protection.
Okay.
And then, Judge, finally, the final proffer is the state's understanding that 2 days on May 2nd, there was not a written Garrity statement at that time. There was instead an oral interview with Lieutenant Merritt that was video recorded that no one on the prosecution team has ever seen because it was removed as part of the screening process to protect the defendant's constitutional rights.
All right, very good. Thank you.
Thank you, Judge.
Any reply, Mr. Gill?
Well, let's start with the last part first. Just
Okay.
the fact that they knew there was an oral statement is something that the Dallas County Criminal District Attorney's Office shouldn't even know. It shows that they have knowledge of that internal affairs investigation, which they shouldn't even have. And there was, in fact, a written statement taken on May 2nd. That's the written statement that an assistant criminal district attorney stood in this court back during pretrial hearings and said that their investigator had reviewed. So they've had that information in their office for some months. And I'm glad to see that the state has finally grasped the issue that we're dealing with here and the extent of the taint that this Garrity interview, this walkthrough conducted under Garrity has on the conduct of this trial and the amount of information the state has gained in the prosecution of this case by the fact that they were present and listening in and conducting that Garrity interview. But as an overarching problem here, we're still pre-trial. We found an application for writ of habeas corpus, which the state vehemently opposed because they did not want to hear this matter pre-trial. We've asked that the court,
hang on, Mr. Glenn.
we have asked that the court hear this matter during trial. The state wants two bites at the apple here. They don't want us to have our habeas rights, but they want to have this taken care of before jeopardy attaches, which is something we offered them while we were at the habeas stage. We offered them, we pointed out to them that we're trying to take care of this matter before jeopardy attaches.
I understand.
Judge, if I may.
You don't need to. Listen, the habeas matter is across the street. I haven't received anything. We've handled that. We're not talking about the habeas matter anymore until I hear from the Court of Appeals, if I ever do. Right now, you've got a motion in limine that you filed.
Yes, sir.
This is your motion. So I would like to know, hear arguments about your motion in limine. And the question that I have in my mind, Mr. Gill, is I don't think anybody disagrees that this initial statement, and please correct me if I'm wrong, at 3:20 would have been a Garrity statement. Is that right?
That's correct, Judge.
We don't disagree.
At 3:20, Mr. Oliver received a Garrity warning.
Okay. Now, their contention is that at some point that stopped. We're done with that in their mind. We go to this walkthrough, and there's DSO there, apparently. There's, I don't know, prosecutors. Were prosecutors there? Other people were there? Besides, and in other words, there was other people there besides Balch Springs police officers.
Yes, Judge.
And he's saying that there's a...
Judge, I'm being told the prosecutors were not present for the walkthrough.
Okay, but there were other investigators that were not Lieutenant Merritt.
Yes, Judge.
This administrative investigation about his employment, in their eyes, has ceased. I can see where they're coming from, so that's what I'd like for you to address with the court. When does Garrity stop?
Garrity doesn't stop, ever. Once that officer has, or that public employee has received a Garrity warning, they're cloaked with their Garrity rights. Any statement they give going forward is immunized.
I don't know that I agree with that. I know that anything that he says initially is immunized, but I think you're reading Garrity too broadly.
He got a Garrity warning. He was told that any statement he gave from that point on to investigators was immunized. It didn't say we're excising statements that are given to the Dallas County Sheriff's Office. It didn't say we're excising statements that were given in a criminal investigation. It said, Roy Oliver, statements you give from here on out are immunized. You have a Fifth Amendment use and derivative use immunity for any statement you give from here on out.
Okay.
Lieutenant Merritt from Balch Springs Police Department, who conducted the entire internal affairs investigation, was present during that walkthrough. I don't know whether he said anything or not, but the mere fact that he was there lends a great amount of credence to the theory that it was conducted by the Balch Springs Police Department as part of their internal affairs investigation.
All right, very good. I'm going to deny your motion in limine this time. I'll give you a running objection. If there is anything specific, Mr. Gill, that you believe might be attributable uniquely to your client, please approach the bench and let me know. Mr. Snipes, are you going to be presenting these witnesses that may potentially have this issue come up?
Possible.
Okay, well, whoever it is for your team, if you feel like we're getting close and there's something gray in your mind, please approach the bench before we go any further. Is there anything else regarding pretrial matters?
One thing, Judge.
Yes, sir.
On the motion limine, we wanted to get clarification from the court.
Okay.
Is during my opening statement,
Yes, sir.
I intend to say that Jordan Edwards was beloved by his family, his friends, his classmates, his coaches, and that he was an excellent student, an excellent athlete, and an innocent kid. And I do believe that I should be able to do that. I don't intend to do anything during the case in chief, like calling school teachers, calling the coaches, and so forth. But I do believe, by way of introduction, during my opening statement, that I should be able to say it.
I'll give you a little leeway to put those matters forward.
And that's too much leeway. I mean, we do have other parts of this motion limine, and I think that the court maybe meant to only overrule a motion in limine as it goes to the Castigar matters.
I did.
There are several other prongs to the motion in limine.
Okay.
I did not hear this directly from Mr. Snipes this morning, but I was told he did not have any objection to any other part of the motion in limine except the Castigar paragraph. And victim character evidence is not admissible during the guilt innocence phase of the trial for any purpose.
All right, I respectfully...
So I understand a little leeway, but that's an awful lot of leeway.
All right.
That's getting into matters that probably aren't even admissible during the function phase.
Well, I'm going to allow him to prove up that the victim was a living, breathing human being, once born, but no longer alive. So if you wish to make an objection, I'll allow you to do that. Is there anything else before we bring the jury in at 9:08?
Yes, sir.
Okay, go ahead.
There are several other parts to our motion in limine. We're asking the state not make any other references to the fact that they provided full discovery to the defense in this case, as they have done. They did it at Fort Dyer. We knew it wasn't true then, and we suspect if it's done during the course of this trial, it's not going to be true at that time either.
Okay, I'll grant your motion.
Any evidence or testimony suggesting Mr. Oliver was suspended, terminated, or fired from his employment at Balch Springs?
No intention of doing that, Judge. I don't
All right.
know that.
Your motion is granted.
Any evidence or testimony or mention of any other charged allegation against Mr. Oliver that's not joined into this trial?
The other aggravated assaults? Is there anything that's not part of the res gestae of this crime that's filed against him?
No, sir.
Okay.
Well, there are two other aggravated assaults that are filed. We heard some testimony on that Tuesday.
Go ahead.
That's 404B, and that will only offer that if the court determines that we can, because
Okay.
defense activities are raised.
Okay. With that understanding, I'll grant your motion.
And then we also asked there not be any evidence, testimony, or mention of any of the other matters they brought up and given us notice of by way of a 404B notice, which are numerous.
Okay. I recall the 404B notice. I've read it. Please don't get into that without approaching the bench first. Your motion is granted.
Judge, at this time, we're going to re-urge our change of venue motion. There's been within the last several days, a lot of publicity, especially regarding matters that were addressed here in court on Tuesday regarding extraneous conduct the state seeks to introduce during this trial that the court hasn't ruled on yet. That was reported extensively on all the major news networks and press here in the Dallas-Fort Worth Metroplex, and we'd ask for those reasons that the court grant our change of venue motion and transfer this case to another county outside this media area.
All right. Your motion for a change of venue is denied, and I do want to alert the parties to an order that I filed yesterday. I don't want to see any lawyers on TV talking about any of this case or any of these proceedings for the rest of the trial. We would greatly appreciate that. We'll stay off the news. Go ahead.
Yesterday, Judge, we filed a petition for writ of mandamus in the Fifth Court of Appeals.
You did.
Along with that, we filed a motion for stay of these proceedings until such time as the Fifth Court of Appeals has either granted or denied our petition for writ of mandamus. I've been checking my email throughout the morning, and we've not heard yet from the Court of Appeals on that issue. We would ask that these proceedings be stayed until such time as we hear from the Court of Appeals on that matter.
Let me check my email real quick. Mr. Gill. I have not received an order from the Court of Appeals staying these proceedings. Your request to stay these proceedings until the court rules is denied.
A couple of days ago, we also filed and had heard a motion for continuance in which our main thrust was that we were continuing to receive discovery from the state of Texas, and that we don't believe that discovery has been completed as of this time. Yesterday, we received an additional 41 pages of discovery from the state. My cursory review of that discovery reveals that there's probably other discovery that's still outstanding. It's based on what we received yesterday. We would ask for more time so that the state of Texas can complete their obligation to the defense and the court in this case and provide us full discovery.
All right. Mr. Snipes or Mr. Higginbotham, Mr. Gladden, do any of y'all care to reply to that, those assertions that were made on the record? Okay. Your motion for continuance is denied.
We filed a motion for the court reporter to take down all proceedings in this case. She's here taking this down right now. But there are going to be discussions had in court while the jury's out. We need to have those discussions taken down by the court reporter. There has been, I anticipate there will be more discussions at the bench.
Yes, sir.
On the case, and we're going to need to have those taken down for the record also.
Yes, sir. We'll do that.
Is the motion granted?
It's granted, yes, sir.
Thank you. The jury has not yet been sworn. Court mentioned 2 days ago that you were thinking about discharging a couple of the alternates.
I did.
And we hadn't heard yet whether that's been done or whether that's going to be done this morning.
It is. Thank you for reminding me of that. The record should reflect that the court selected 16 total jurors. There were 2 alternates. Their names are part of this record, number 16 and number 15. I released them this morning because all 16 jurors showed up. All of them looked in good health to me. I don't see any reason why I need 16, and plus I don't have any room for them. So I'm going to, and I did release those two, jurors number 16 and 15, that the record shall reflect has their names.
We would ask that we be allowed to additionally board hire this jury to see if they have if any of the additional publicity that has occurred since it was June the 29th when we last saw them has caused them to form an opinion or has influenced them in any way that might influence their verdict in this trial.
I'll address that very briefly with the members of the jurors. I will let the record reflect that I have communicated with the jurors when I told them they were going to be jurors, and also when I called them and told them they were still required to be here today, that I reiterated all my instructions regarding doing any independent research. They all followed it. I will briefly admonish them when they come in. I don't have any reason to believe at this point that they have any information that would cause them to be disqualified, so I'm going to deny your request to that extent to individually voir dire the jurors.
We've had discussions this morning about excusing certain persons from the rule, I believe.
Okay. Do y'all have an agreement? Do you need me to settle any disagreements?
I think we do. I'm not just exactly sure what it is because I didn't participate in it.
Okay.
Mr. Lane and I talked about it, Judge. We're letting his common law wife stand here. And Mr. Lane very graciously allowed Ms. Edwards and Mr. Edwards to stand.
Very good.
And Judge, the state would have one request with respect to the defendant's common law wife, is that she was a grand jury witness, and the defense has raised the Garrity Castigar issue, part of which could influence this court's decision on how evidence was presented before the grand jury. To the extent we have any sort of Castigar type hearing for any witness, the state would ask that the rule be invoked with respect to her during that hearing.
All right. Sounds fair and reasonable to me. Thank y'all for working together on that. Mr. Gill?
That's all we have, Judge.
All right. Are y'all both sides ready to bring in the jurors? Very good. Mr. Lewis, sorry, I'm going to have to ask you to move. That's where my alternates are going to go. Okay. Welcome.